Good evening. I'm Robert Tanner. The other board members are Mike Martin and Scott Calhoun. We need to introduce the following people: Matthew Puz, Zoning and Development Officer; Julie Maggio, Assistant Zoning and Development Officer; Rich Perhax, Board Solicitor; and Cecilia Mahana, Court Reporter. After the presentation by the appellant, the board will hear from all interested parties in the appeal, whether in favor or in opposition to the appeal. After all presentations are made, the board will recess. We will then reconvene and make our decisions. The board has up to 45 days to render a decision. Most are made this evening. You may call the zoning office in the morning after 8:30 if you choose to leave before the decision is made on your appeal. I would now ask that everyone please stand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? Please answer, I do.
I do.
Thank you. Anything that you present and show to the board tonight, we will have to keep for up to 60 days. The first appeal for tonight is appeal number 21-14.
15.
Yeah, you have.
Okay, we'll go back to
You have to deliberate on
21-14.
14 later.
We'll deliberate on that later. So appeal number 21-15, Richard and Aaron Polinsky for property located at 1731 East Grandview Boulevard, asking for dimensional variance to construct an addition within the rear yard setback in the R1 Single Family Residential District. Whoever's here to speak on that, please approach the podium. First thing, we'll need your name and your address.
Hi, Richard Polinsky, 1731 East Grandview Boulevard.
Erin Polinsky, 1731 East Grandview Boulevard.
Okay, please just take some time and give us a little rundown on the project.
Okay, our rear deck on the house and the front entry, little porch out front, they need to be replaced. And upon trying to find out about getting our rear deck done, it's a 16 by 20 deck. The house was built, I guess, before the zoning things. We have the variance or whatever, trying to see what you call it here. Yeah, the zoning exemption thing to replace those. And on looking at the deck from the side, there's posts in the corners, there's 2 posts on either side of the steps, then there's posts in between those. And we'd like to put a roof over the center part of the deck. Be better than just having umbrellas.
So one question on that is I see there's a sketch drawing here of the deck, and it shows a roof, but then it's crossed out, the roof and the description of the roof.
Yes, when they said we couldn't put the roof on, that we have to go through the zoning appeal stuff, oh jeez. And so we got the exemption for just doing the deck without the roof, and then we decided, well, hey, let's spend $500 and see if you guys will let us do it.
So your deck size is gonna stay the same, you're replacing the existing
Yes.
footprint,
Yes,
and you wanna put a roof over a certain portion of it.
yes, just
Okay.
kind of like the middle part of it.
That way, so during the summertime, we are able to enjoy being out there, because it does get hot, and we like to be outside, and having umbrellas just doesn't cut it. We'd like to have something a little, well, much more permanent, so that we are able to enjoy that space.
So that I understand, you're gonna replace the existing deck with a new deck in the same spot,
Correct,
same footprint, but you're gonna put a roof over part of it.
correct.
Okay.
So Matt, if they replace the deck in kind, right where it is, they don't need to be here, it's only for the roof?
Correct.
Right, that would be just a replacement of a non-conforming use, which,
Right.
as long as they're not expanding it or modifying it, which they're not, other than the roof,
Yes.
they don't need to be here. That's true.
And what is the property that's behind you there?
That's
33 acres of woods.
Larson Text. They wanted a couple of years ago. They planted, I guess they're just gonna have it as part of their campus.
And there is a double wooded lot, and to the west of us is a double lot that belongs to Mr. Harden, who's our neighbor over there.
Have they indicated any issues with any of this?
No.
Any other questions, Scott? Mike? Rich?
No.
Okay,
Does anybody in the audience have any questions?
all right, if you want to take a seat, we'll go ahead and, deliberate on this after we hear the other appeals.
Thank you.
Okay, next appeal is 21-16 Meadow Green Acres LLC for property located at 2728 West Park Lane, asking for an expansion of a non-conforming use to install a mobile home in the RR Rural Residential District.
Good evening. I'm Cindy Money. I'm the manager of Meadow Green Acres. We would like to replace a 1983 used smaller home with a new 2021 larger home. And we are in a rural residential district, so it's considered non-conforming use to replace an old home with a new home. So, what we're proposing is to take out everything that was existing and replace it with all new buildings.
This new home is more of like a different shape. It's like 28 by 44.
Correct.
Is this like a manufactured home as
It
opposed
is.
to what I'd call, a trailer or a double wide?
It's a double wide.
Oh, it is?
Mm-hmm.
Okay, the terminology I may be incorrectly using. Okay. Is there a photograph of the proposed new building? Because you have a photograph of what you're taking out, which
Right.
does not look very nice.
So, no, it's still in two pieces, waiting for the outcome of this
Okay.
hearing.
By virtue of the drawings that you have, it doesn't appear as though it's twice as wide. Would it fit on that lot?
Yes, although it is twice as wide, it is shorter, it's much shorter. So, we're able to pull it forward, the home forward, missing any trees that were on either side of it. So, although we're taking those trees, the one tree down, it does still fit on the same lot.
Matt, is there any issue relative to spacing between this unit and adjacent units that requires the board's attention?
No,
Okay, it's just the notion that they're changing what's shown in the photograph with what's depicted on the plan.
correct,
A different shape and a different configuration and size.
yes, correct,
But other than that, but that's the only thing that brings them here.
yes.
Okay. Because I know we've had issues there before where, you guys have come in for like 6 of these at once, and, there's a foot here and 6 inches there and 2 feet over here, that is closer, but that's not what's involved here.
No, it's that our area is no longer, a mobile home park is no longer able to be in the rural
Right.
residential.
Yeah,
so
we're,
It's a non-conforming use,
Yeah.
no matter what the size is if it doesn't fit the exact footprint of the,
right, yeah, no, they're administering it correctly. They need to, you need to come here when you do this, because we have to make sure that it's not offending other things, that we're concerned about. But, so this is the process that you have to go through. And we're painfully aware of the zoning regulations in this area.
yeah, I'm sure you are. It is a little frustrating for us simply because to upgrade actually is better for everyone.
Well, certainly, what you're taking out, isn't very attractive based on the photograph. I don't see the new one, but it can't be like that.
No, they are built and they look very much like a ranch home when they're put on their property. So there's not a lot of difference in a mobile home park, they have to be on skirting. So people look at that and say, oh, you know, that's a manufactured home. But otherwise, very few people can tell the difference if it were on a big swing.
Okay, I don't have any other questions, do you? What? Okay, does anyone in the audience have anything? Okay, thank you. All right, next up is Appeal 21-17, Randy Wayicki, I'm gonna guess at that? For for property located at 2023 Andover Lane, asking for a height variance for a fence along the frontage of Dixon Drive in the R1 Single Family Residential District.
Randy Woyicki, 2023 Andover Lane.
Okay,
I'm requesting a fence, a height variance from 4 feet to 6 feet on the frontage of Dixon. I'm requesting it for multiple reasons. Where the building line is on the property, essentially I'd be cutting my yard in half. If I put a 6-foot fence, it gives privacy. I have a dog, I have a young child. It stops people from looking in my yard, it stops people from coming over the fence, especially lately, we've had a lot of vandalism in the neighborhood. Also, by getting a 6-foot fence, I'm not blocking any, I guess, view from the street. I'm also not hindering any driveways, because from Grandview Boulevard all the way down to Berkshire Lane, there is no driveways on that side of the road. So I wouldn't hinder anybody's view. I wouldn't hinder view from oncoming traffic or from people coming out of their driveway. I do have a very large dog. He's a very happy dog, but he's a country dog. He likes to bark at things. So at 4 feet, the only thing he's gonna see is heads go by and bark at him. At 6 feet, he won't bark. And with the traffic coming off of Grandview, it would be a lot safer for my child playing in the backyard. I do worry about the traffic coming down the hill. And I did speak to all my neighbors. And I
Who
do
is
have
that?
all their signatures.
Whoever that is, attend to it?
That might be mine.
Okay, the one guy who can't get to his phone. Thank you.
I apologize for that. I also did speak to all my neighbors. All the neighbors that are on the corner lots adjacent are all signed that they're in support of me doing that as well. And there's also other fences in the neighborhood and surrounding area that are 6 feet on a corner in a similar situation that I am. I don't know if you'd like me to bring this up to you.
If
What is
it's
that?
something you want to show us, sure.
It's totally up to
Yeah,
you, as long as you leave it here.
I spoke to all my neighbors that are on the corner lots surrounding my house and my next door neighbor, and they're all in support and have no objection to 6-foot fence.
okay.
I'm looking at your paperwork, and I see the fence depicted on a drawing, looks like 35 feet on one leg and 55 feet on the other. Is that an accurate
Yes.
representation of where the fence will go on your property and how long it will be?
Yes, it is, sir, within probably about a foot. And it's only gonna be about a third of the yard, so I'm not even coming up that far.
Right, well, I just want to make sure that if the board approves this, that it's specific enough that you know exactly what it is you're entitled to do. So I'm going by what you put down.
Yes, that is the measure.
If that's not accurate, you need to tell us, but,
No, it's very accurate.
okay, thank you. I don't have anything else.
Yeah, I don't, okay, I don't have anything else
All right, thank you.
for you right now, thank you. Is there anyone in the audience who'd like to speak on this? Thank you. All right, next one is appeal number 21-18, Sarah Lohr, for property located at 5120 Fox Park Drive, asking for a use variance for a personal service in the RR Rural Residential District.
Oh,
Mr.
that
Chair.
was withdrawn.
Yeah, that we got it. This is when we got the.
This
Oh,
is,
this
the
is
one that was
withdrawn.
withdrawn.
Yes, this was withdrawn Monday.
Okay, understood. Appeal Appeal number 21-19, Robert and Catherine Umpleby for property located at 2916 Broad Lawn Drive, appealing the determination of the zoning officer to deny a permit for a front porch that infringes beyond a recorded building line and would violate the subdivision and land development ordinance in the R1 single-family residential district. Who's here to speak on that?
I wasn't certain if the attorney would go first, or if you wanted me to talk to you first.
If you could speak first, please.
All right. My name is Kathy Umpleby, and I live at 2916 Broad Lawn Drive with my husband Bob. We've lived in our home for 43 years. My husband and I are very emotionally involved in this 8-month-long process, and we respectfully request a bit of latitude to allow our son Michael to ask questions of Mr. Puz on our behalf. Would that be all right?
Well, as long as he comes to the podium and says his name and address,
Okay.
certainly welcome.
Um,
We just need to make sure that only one person speaks at a time.
That's fine. I had provided Mr. Puz, just so that you know, with materials to be distributed to this committee. I trust that you've all received those.
Well, we received a big package of stuff.
Okay.
I don't know what you submitted exactly, but it looks pretty thorough.
Okay. All right.
I am Michael Umpleby.
If
My
I may,
address?
before we begin, I'd like to ask Mr. Umpleby some questions regarding his qualifications to participate in this process, concerning practice of law in those regards.
Well, I would advise the chairman to allow you to ask your questions, because you're entitled to put that on the record, though. As a practical matter, I understand the point, believe me. But I've been solicitor here for something going over 30 years, and I've seen cases presented by aluminum siding salesmen, real estate agents, the next door neighbors, friends, all manner of people who don't have law licenses. It's rather common practice, actually, to give property owners latitude to present their information however they want, knowing that if we say no, it's going to, and as an appeal taken, it's going to get sent back and it's going to be reheard. And the most efficient way to do it is, as long as it's competently done, it's not irrelevant, and it's regulated by the chair so that it's orderly and pertinent. And we generally will allow somebody who's not licensed to speak in support of or on behalf of, of an application. And anybody who speaks as a member of the public, which he is entitled to ask questions of anybody else participates, I think, is a matter of due process. So for all those reasons, I would advise the chair to allow Lydia to ask her questions so that she can put on the record her position on the question of participation by this individual, or whatever that position may be. And then we'll go from there and try to do this in an orderly fashion. So I would recommend that the chair that we permit Lydia to preliminarily ask those questions.
Go ahead.
Thank you, Mr. Chairman and Mr. Perhacs. Mr. Umpleby, are you licensed to practice law in the state of Pennsylvania?
No, I'm not.
And what is your qualification to ask questions of the township zoning officer?
I have been investigating insurance claims for the past 21 years. I've participated in litigation. I have looked into probably 10,000 claims. I have obtained thousands of recorded statements, and the zoning ordinance reads a lot like an insurance policy, so I'm comfortable looking at it, and I just am trying to help my parents.
I understand. Are you the property owner?
I am not the property owner.
And do you have any other background in zoning?
No.
Thank you.
Do you want to state, a position on his participation?
Yes, I would like to state a position. The Pennsylvania Bar Association has issued an opinion regarding the unauthorized practice of law. It's from 1991. Its formal opinion is 1999-101 concerning the unauthorized practice of law as relates to participation in zoning hearing boards.
Oh, really?
Yes, and it would be our position that anyone, if a landowner is representing themselves pro se individually, there's no problem in them proceeding
Right.
in that fashion.
Right.
But if they're being represented by someone other than themselves, such as a siding representative, a contractor, an architect, or in this case, their son, we do not believe that it is appropriate practice of law in this regard, and that they would not be permitted to participate as their counsel.
Okay, may I have a copy of that?
Yes.
I'm not familiar with it. Well, here, one moment, please, off the record.
For anyone who came into the meeting a few minutes ago, I just want to let everyone know that appeal number 21-18 for Lauer was withdrawn. So if you're here for that one, it was withdrawn from the agenda. Okay, do you want to- Yeah, after having deliberated briefly on the matter, a couple points. First of all, in light of the objection of the township solicitor to your questioning witnesses, would the applicant prefer to continue this hearing and retain counsel to deal with it? Or do you want to proceed as you are without counsel?
We're proceeding without counsel.
Okay, so you want to proceed without counsel, okay. Okay. That being the case, we will proceed. I am advising the chair that the opinion that's been submitted by the township solicitor from the Unauthorized Practice of Law Committee of the Pennsylvania Bar Association, regardless of how persuasive it might be, is nonetheless not an order of a court. It's not a judicial decision. It's not a ruling by the ethics authorities. It's simply an opinion of the Pennsylvania Bar Association acting through its committee that investigates such matters. And regardless of how persuasive it might be, it is not binding on the board. I'm going to advise the chairman to allow the questioning to proceed under the objection of the township solicitor, which has been recognized. I would advise the chair to, and the individual who's purporting to do the questioning, that your questions have to be competent, and they have to be relevant. Okay, we're not going to meander, we're not going to get repetitive, we're not going to get argumentative, we're not going to get off the point, which we don't know yet what it is, because there's nothing in the record. Okay, so we're gonna keep a close rein on this proceeding, because you're not trained in doing this, and there's been an objection made. So with that understanding, then I would advise the chair that we allow you to proceed.
We'll allow it.
Okay, thank you.
I would suggest to you that the best way to proceed, first of all, is to place into evidence the subject matter of the dispute. Because we don't know anything yet. All we have some papers, and that doesn't count. So before you start cross-examining Mr. Puz, you need to explain to the board what it is you want to do, why you had a problem getting approval for it, and what brings you here. That needs to be placed into the record. And if there are facts necessary to establish that, they need to be competently put into the record. So that's your job right now,
Okay.
okay, before you start firing questions at people. Okay.
Pardon me. Beforehand, I also wanted to inquire if the board would prefer if I made an opening statement at this time or whenever we get to our case in chief for the township.
Somebody needs to frame this issue for us so that we have an understanding of, I only know what was written on the agenda as to what the nature of the issue is. I understand there's something's being done, it's extending into a setback.
Certainly.
That's in a recorded subdivision, and that requires various procedures to modify, and those weren't followed or weren't satisfied in one way or another. Therefore, a permit for the construction was rejected, and there's an appeal taken from the denial of that permit. Is that about right?
Generally speaking.
Okay, that's all we know.
Certainly, and I'm happy to provide a general
Why don't we
oversight of the
do
township's
that?
position, but I will
And-
defer to whatever the board prefers.
I'd rather have him present his case typically.
Well, we would. Yeah, I'm fine with that, too. I'm fine with that. I'm just trying to do this the most efficient way we can.
Okay. Okay.
However, whatever you want to do.
All right, go ahead, Ms. Caparosa.
Thank you, Mr. Tanner. You have received the various documents from the township, is my understanding, concerning the appeal related to 2916 Broadlawn, which is an appeal from the determination of the zoning officer. Mr. Puz denied the permit application because it does not conform to the requirements of all of the pertinent township laws. Specifically, that no structure is permitted beyond a recorded building line. The focus of the board's consideration tonight is really on whether or not Mr. Puz, in interpreting the zoning ordinance, incorrectly interpreted or applied it when he determined that the application as submitted by the Umplebees did not conform to a recorded subdivision plan that was approved by the township and included a 30-foot building line, and whether he could not, because of the recorded subdivision plan with the building line, issue a permit. The Umplebees desire to construct an open porch on their property that would extend about 6 feet, I believe, beyond the recorded building line.
So the home currently is built right at the front building line?
I believe there's about 4 feet from the building line.
So the encroachment is 4 feet?
It's currently 4 feet back from the building line, so the encroachment would be 6 feet.
Okay. Yeah, okay. Let me see.
Do you have anything else to add to your?
That is all at this time.
Well, there's a current porch that's 4 feet deep. So that's why I'm saying it's at the building line. If there's a new porch that's 10 feet deep, current porch is 4 feet deep, and this is a 6-foot encroachment, it'd be my understanding that it's built at the current front building line.
So the encroachment is 6 feet.
Encroachment is 6 feet. Currently, the face of the porch is at the front building line, would be my, from the documents that I have, that would be my understanding.
Okay, and the building line at issue is a 30-foot setback.
So is the 4
Right.
feet in violation of the 30-foot?
No,
No.
the additional 6 feet would violate the open building line.
Okay. And that building line is 30 feet from, what, the right-of-way, or how's it measured?
Correct. The
You
building
can't go-
line begins, you measure in 30 feet from the front property line, which would be
Right,
the
so
beginning of the
you've got
right-of-way.
30 feet from the front property line, and this goes 6 feet into that.
No. Oh, the proposed porch,
Yeah,
yes.
Yeah, okay, so I just wanted to get my arms around.
We're
the
removing a
extent
4-foot deep porch and putting on a 10-feet deep porch.
Which
It's 6 foot greater,
makes it go 6 feet
makes
farther.
6 feet toward the
Got
property
it,
line.
okay. I understand. Does that sound correct? This is what you want to do?
Yes, it is.
Okay, because that's what we needed to get in the record, what the proposal is. Okay, we got that. Now you may proceed to present whatever evidence you think is relevant.
Okay. Again, I'll say thank you for letting me do this. I drove 100 miles to be here to help my parents, so again, sincerely, I appreciate you letting me participate. Mr. Puz, on the application, in your notes on denial, the only ordinance that's noted on there specifically is 145-108, number 2A. Is that correct?
Correct.
Okay. And that is the ordinance that gives you the authority to deny the application if there's something that's outside the ordinance, correct?
Correct.
Okay. Is there any other specific ordinance that this would violate?
I'm going to interrupt you for a second here, sir. This is sounding like cross-examination to me,
I would agree.
and that's not what we're doing here.
Okay,
We'll permit you to question Mr. Puz if he testifies,
okay,
and we'll permit you to, you may cross-examine him after the township solicitor has elicited whatever information they want from Mr. Puz.
okay,
This is the part of the case where you present what you want to do and why you think you're allowed to do it, okay?
okay.
And he hasn't said anything yet.
I
Now, you
can-
can, if he has information that only he has, and you can only elicit it by asking him questions, you may call him as your witness,
Okay.
okay?
I can,
But that's a whole different approach to the question.
okay. So I can summarize our position, how about that?
That's really what you should do at this
Yeah.
point.
Okay.
And then let the township explain why it turned you down, which I'm sure they're prepared to do. I mean, I'm sure they're prepared for that. It looks like they are. And then you may ask relevant cross-examination questions
Okay.
after they've done that.
I can do that.
Does that make sense?
Yes. When I say we, I mean my parents, my family, okay?
Well, you're speaking for them, so
Okay.
we're taking that as,
We have submitted an application for a permit to allow us to do what section 145-19 subsection F authorizes us to do. That's to erect an open front porch that would extend not more than 10 feet beyond the required 30-foot building setback line, which would not intrude beyond any side yard setback lines. That there is a front yard setback line shown on the 1958 subdivision plat, we feel is irrelevant. Today's subdivision and land development ordinance requires that building setback lines established in the zoning ordinance be noted on a final plan application. The point of requiring that front building setback lines established in the zoning ordinance be shown on a final plan is to help enforce the setback regulation. Yet today's zoning ordinance allows an open front porch that intrudes up to 10 feet in that front setback. There is no provision in the subdivision and land development ordinance that applies here, and certainly none that supersedes the zoning ordinance. This is not a question of some rights others can enforce. There are no restricted covenants of record for this subdivision. And even if there were, the township has no legal authority to enforce them. If anyone believed that there was a private right to enforce the front building setback line shown on a map, the time to do that was when the Board of Supervisors enacted Ordinance 2014-8, which created current Section 149-19, letter F. Our understanding is that no one did so, and our understanding is that no one has challenged the ordinance. Section 145-108, subsection A, number 3, provides that where the proposed work conforms to the requirements of the zoning ordinance and other ordinances, the zoning administrator shall issue a permit. That a final development plan shows the front setback line does not become some basis for denial where the zoning ordinance expressly allows what is being requested. Our application met all requirements of the zoning ordinance and all others. The zoning officer has no authority to ignore provisions of the ordinance that on their face allow what we have proposed to do with our property. For these reasons, we feel the zoning administrator erred in denying the application, and we would request that he be directed to issue the permit without further delay. Again, since the zoning ordinance specifically allows what we would like to do, we are respectfully requesting the return of the $1,000 fee for this appeal. Since the zoning ordinance specifically allows the building of a front porch as proposed without the need of a variance.
Okay, you are now subject to questioning if the township solicitor wishes to. Do you have any, is there anything else to present initially in your direct case, or are you done with that?
Do you want to mention the properties?
Yes, may I mention a couple of other properties?
Well, let's wait until
Okay.
we see if there are any questions for
All right.
this gentleman first.
I do have some initial questions. You refer to the subdivision map. Are you familiar with the subdivision map for your parents' property?
Yes.
Is this a copy of that subdivision map?
Yes, it is.
I've marked this as Exhibit 1.
Thank you, Lydia.
And could you please indicate to me where on this map it says that there is a setback line?
Yes, the line runs parallel to Broadlawn Drive. It's marked 30-foot building line.
But it doesn't say that it's a setback line.
No, it says building line.
Is there anywhere else on this document where you have determined that there's a setback line that's 30 feet?
No, the only line marked is the 30-foot building line.
And is it your position that the building line, or excuse me, the setback line is what's represented on the map?
Yes,
And does the township ordinance define a building line?
it does in section 125.
And what is that defined as, do you know? If you don't have that, that's fine.
I can paraphrase, but basically it says that no structure will be built across that line.
And that is a building line, correct?
Mhm.
And you referenced section 145-19F
Yes,
of the township's ordinance that concerns,
I have copies if you need it.
That references that, you know, an open porch may be erected in the front yard, extending a distance not more than 10 feet beyond the required building setback line, provided that it is not located closer to an adjoining lot's property line than is required width of the side yard. Is that correct?
Yes,
And is building setback line defined in the township's ordinance?
yes,
And does this ordinance specifically say building line?
no,
Does it say setback line?
no. Building setback line,
And that's a defined term under the township zoning ordinance.
yes.
And you indicated that the subdivision map that was recorded, was that, going back to Exhibit 1, was that subdivision map approved by the Mill Creek Township Supervisors?
Yes?
And to your knowledge, nobody objected to that subdivision map?
To my knowledge, no.
And this map was recorded in the Recorder of Deeds office?
Yes?
Did you participate in any meetings with the township concerning its determination as to the building line issue with this property?
No.
So you don't have any knowledge, personal knowledge with respect to the township's position?
It's just what my parents have relayed to me.
And in regards to your position that the application conforms to all of the appropriate township ordinances, does this application conform to the requirement that all permits issued must conform to recorded subdivision plans?
Yes.
In what way?
Our belief is that the building line as defined in the subdivision and land development section is a requirement of the builder when they submit their final plan. So they have to list a building line, and that reflects the required front yard setback for R1 zoning district as defined in the zoning ordinance.
And does the subdivision and land development ordinance require that the building line be the same as the setback line?
It has to be at least at the building line.
And where in the township's ordinance does it contain that provision?
I don't know the exact location. I don't know the exact location of the wording you're looking for.
Is it your position then that if there's a recorded subdivision plan with building line restrictions and other restrictions, that because your parents, let me rephrase that. Is it your position that restrictions on a subdivision map are not applicable to your parents' property?
I don't believe that the building line is a restriction on my parents. I believe it was something that the builder had to represent on the final plan before that plan would be approved. They have to put a building line on there.
And does the township's ordinance, as previously discussed, state what the building line requirement distance is?
Yes, front yard setback, it's in section 145.
In the section 145 in the zoning ordinance?
Yes,
That's not the subdivision ordinance.
I guess I don't understand what you're asking me.
Is there a requirement for the building line to be the same as the setback line?
No,
If there were other restrictions on the subdivision map, such as, not permitted to subdivide, not permitted to, or easements for that matter, and they happen to cross your parents' property, are you saying that because it was required to be put on there by the builder, that it doesn't apply to your parents' property?
we're not talking about an easement, so I don't see how that's relevant.
But there are restrictions that are placed on a subdivision map,
I understand.
and the building line is a restriction on the subdivision map. Or do you not agree that the building line is a restriction on the subdivision map?
The building line, as I read section 125, seems to indicate that the developer has to mark the building line where they will not cross with any structures.
What's the difference between a
I can
buil-
refer you to
building
section
and a property line?
145-105F of the zoning ordinance. If you don't have a copy, I can provide you with a
If I could
copy.
see it, please.
So, if I may, your position, sir, is that the contractor who originally built the house has to observe the building line. But once the house is sold, the property owner can ignore it and go out as far as they want. Is that your position?
That's not what I'm saying.
That's what it sounds like. If that's,
Can you clarify that
yeah,
position?
clarify that for me then.
Sure.
That's what you just said.
In the zoning ordinance for R1 zoning district, the front yard setback is 30 feet. My understanding that as I read section 125, in the final plan for the neighborhood, in this case Cloverleaf Homes, has to represent a setback in that front yard of nothing less than what the setback is as noted by the township, which is 30 feet. And so they have to show that line.
It's
They can-
something,
And would you agree that no structures can be built closer than that line?
I agree that in the subdivision section, that term says building line and then no structures may be built across. I believe, yes.
but that's what you're doing. That's what you want to do.
But the building line and the front yard setback line are the same line.
I'm confused that
Yeah, that-
you're acknowledging that a structure can't be built closer than 30 feet to the street.
When the home was built, yes.
So then after the home is built,
Yeah,
people
yeah,
can do
well,
its
that's what I
carte
s-
blanche?
That's what I asked him when I started asking the question. There's a so the property owner can just, the next day, they move in, they can just go across the line, and how far can they go?
But even still, 145-19F permits the open porch built across the front yard
Well,
setback line.
145A2 says that Mr. Puz can reject a permit application if he finds it inconsistent with any law or any ordinance, including the subdivision and land development ordinance, which is where I think you had your problem. So that's really, I think, what you need to address.
Let me ask this question, if the existing porch is already 4 feet beyond what I'm gonna term the building line, is that correct? How did that get built?
Existing porches at the building line we established. Existing porches at the building lines, it's 4 feet deep. The request is for a 10 feet deep porch, so it's 6 foot further
Right.
for a 6 foot encroachment.
Yeah, right. Existing porch is
So
perfectly
in
right.
other words, if they would come here and ask for a 6-foot variance, we'd be able to discuss that.
They would still have a problem with the subdivision and land development ordinance, which we're bound, and Mr. Puz is bound to apply, and which we're bound to consider. This is not a zoning case.
It's not a variance, it's an encroachment.
That's exactly right. This is in our jurisdiction under the planning code, but it's not your run-of-the-mill variance case, because we could grant a variance from the restriction if the restriction that was giving him a problem was in the zoning ordinance, but it's not.
You understand what all we're saying
Right.
now?
Not entirely.
Well, I think I got my arms around it now. Yeah, the restriction that's a problem is not created by the zoning ordinance. It's created by another land use regulation scheme called the subdivision and land development ordinance, which I assume the solicitor is going to explain to us why and how this proposal violates that. But that's it. This is not he's not asking for relief from the zoning ordinance. If it was that, it'd be very simple, but it's not.
Do you understand there's two different,
Yeah, there's two different ordinances. The township regulates land use and development in a number of ways. One of them is the zoning ordinance, which we're most familiar with, which lays out all kinds of regulations, including setbacks and things that sound very much like what's being discussed here. But that's not the only regulatory ordinance that the township has adopted. They've also adopted a subdivision and land development ordinance. And to get the permit, you have to satisfy everything. And that's what the zoning ordinance says in 145A2. That Mr. Puz is supposed to reject the application if it is inconsistent with any applicable regulation, not just the zoning ordinance.
so they could build a new 4-foot
Oh, yeah,
porch?
I think. They don't, they would just be,
Because it's existing footprint.
yeah, it would just be, yeah, it would be, yeah, right. It wouldn't be violating the subdivision and land development ordinance presumably, because it's not in the building line, which seems to be the part of it that's the problem. So, yeah, true. I'm just thinking out loud, I'm just trying to frame this for everybody so that we know where we're going with it.
If I may,
Well, I interrupted Lydia's questioning, so I want to make sure she has her opportunity to finish. And then you can say whatever you want when you're,
building line is simply a defined term. That's not it's not an ordinance, it's not a reason for denying, it's simply a
It's
defined
not-
term.
I would suggest to you, it's not that simple, sir. But anyhow, do you want to continue?
Rich, can I ask why that would be?
What?
That comment, why it's not that simple?
Well, because the subdivision ordinance, I assume we're going to hear, requires that things like a building line be placed into a document and properly recorded, and they become the recorded restriction, the building line becomes part of the approved plan, which is sanctioned by the subdivision and land development ordinance. It has to be, it's enforced, I mean, the township doesn't require those things to be put on a plan for, just for giggles, okay? They're on there because they have to be followed.
Is there a distinct difference between a building line and a setback line as he's indicated?
Different terminology for the same concept.
We believe it's ambiguous.
But the discussion, as I'm understanding it, has to do with the subdivision ordinance, not a zoning ordinance.
But we haven't heard yet why
We
it was,
haven't heard.
why it was rejected.
And I
Presumably,
think-
we're gonna hear that.
I think we'd be better off, rather than us just
I think we ought to
questioning.
let these people get all this stuff
Yeah.
out. Because I'm sure it'll make, the issue will be more clearly framed once the township has had an opportunity to frame it for us, I think, I assume. Or Mr. Puz can explain why he did what he did. I assume you're gonna present Mr. Puz as a witness.
I do have Mr. Putz as a witness.
Okay, so and you're gonna get a chance to question him on cross-examination after he's presented, so you'll have
Thank
that
you.
opportunity.
I do have one additional question, though. You had asked a question that the gentleman could not answer about where something appeared in an ordinance or something. Do you have the answer to your question?
My understanding is there is nothing in the ordinance that specifies that the building line must match the setback line.
Okay, I was just wanting to clarify, because you asked a question, he couldn't answer, it, and I didn't know whether you had some definition, but you gave it to me. Thank you.
Go ahead,
Did you have
Lee.
anything else?
No, just checking. Mr. Umpleby, so it's your position that the application as submitted complies with the recorded plan that was approved by the Mill Creek Township Supervisors?
Yes.
And that would include, are you familiar, beginning that portion with, section 145, 105 of the zoning ordinance? Specifically application for zoning permit? If not, I have a copy of it. I've marked this as exhibit 2.
Probably what I have here already.
And if you could please turn to the third page, under 145F. And I'm going to direct you to 145F7. Could you please read this provision?
Sure. It says, if the land subject to the proposed building, structure, renovation, and/or addition is located within a subdivision or land development previously approved by the Board of Supervisors, the owner shall be responsible for ensuring that all grading, stormwater management, easements, conditions, and other terms imposed on the approved plan are preserved and/or complied with during and after construction.
There you go.
A grading plan shall be required whenever revision to the above grading plan is proposed.
And would the proposed addition to your parents' house comply with the recorded subdivision?
I guess I don't know how to answer that question. because we believe that the setback line is the same as the building line.
And the subdivision land development ordinance defines building line as you previously indicated, as a line within a property generally parallel to the street line between which and the adjacent right-of-way no structure may be built.
Yes, I agree, that's the definition.
And would you agree that your parent subdivision map indicates that there's a 30-foot building line?
Yes.
Your parent subdivision map does not indicate that there's a 30-foot setback line.
Oh, correct.
Does the subdivision and land development ordinance define setback, to your knowledge?
The building setback line is a defined term. Is that what you're asking me?
No, in the subdivision ordinance, is setback line defined?
I don't have all the definitions in front of me.
And you indicated that building setback line is defined.
Yes,
That's defined in the zoning ordinance.
yes.
If there were other restrictions as part of the subdivision, do you believe that they would have to apply to all of the property owners in your subdivision, your parent subdivision?
I don't understand your question.
Do you believe the 30-foot building line that is on the subdivision map applies to all property owners?
Yes,
So all of the property owners in that subdivision must comply with the 30-foot recorded building line?
yes,
And you've previously discussed that the section 145-19, specifically G,
F,
I'm sorry, I saw 10 feet and went to there, concerns an open porch may not extend further beyond 10 feet than the building setback line.
correct.
Does your parent subdivision map include a building setback line?
I believe that it's the same thing as what's marked as a building line.
And does the township zoning ordinance define building line?
No,
All the current questions I have.
Yeah,
for
this is getting kind of
Mr.
circular.
Umpleby, yes,
The
I
po- the-
recognize
the
that.
point has been
And so I
made.
will
Yeah.
move on, but reserving questions for Mr. and Mrs. Umpleby.
Yeah, you can, if they testify, you can cross them, and if they don't, you can call them if you want. I mean,
I plan to, I just didn't know if they had
Okay,
any further
sure.
questions after.
okay, so you're finished? You're done?
I'm done, yes.
Wait, do you have any other witnesses?
no.
So that rests the case for the applicant? That's what it means when you don't have any other witnesses.
Well, my mother is not a witness.
Yeah, well, she's saying if she's gonna testify in support of the application, she's a witness. I mean, you don't have to question her, she can talk unprompted if she wants to, but if she wants to give testimony in support of the application, she needs to do it.
For the record, I'd like to add that there are 2 homes located in the Westminster Colony Subdivision 1 and 2 at 3110 Broadlawn Drive and 4118 West 28th Street that have had open porches added to their properties. It would have been necessary for these homes to receive a variance for their project since they were done prior to the enactment of 2014 of Ordinance 145-19F. With the existence of past practice and the addition of Ordinance 145-19F, it's our belief that our project should have been granted for the price of a building permit, and there's already people who have done what we're asking you to do. There's people in our area who've already done it,
I have a question.
and they show up on your maps, on the township's maps that I provided you.
A question, Mrs. Umpleby, or
Yes.
to Matt. You're testifying that there's homes that may have had variances granted. Do you know that for a fact?
I
Did you
assume,
ask the zoning office prior to that?
the
Because-
only reason I'm assuming that is because on your maps that you have on your website, there is an X on them. I've provided them to you. And it shows that they're clearly over that line. So past practice would dictate that if they did it, I don't care when they did it, you know about it. You've never gone after them, obviously, or they requested a variance. And if that's the case, they've already done it. They've already done it.
What you're giving us testimony that is conjecture, not fact, and that's why I asked the question, do you have any data or any evidence that there were variances granted for that?
I
Because we
do.
can only take it for
No,
what it's worth, it's
No.
testimony that,
I do not know that, but I can tell you that they're there. I could go see them.
well, we don't disbelieve what you're
No,
saying,
I
but
understand.
but it still comes down to being,
I'm getting too nervous, I'm sorry.
no, you're fine.
But they're on the map. They're clearly across the line on the township's
Well,
map that are published.
It may not seem right to you, but I can tell you without hesitation that the argument that I'm entitled to relief because somebody else did something that violates an ordinance doesn't get you very far.
I understand that.
Okay, well, that's essentially what you're saying.
But you know what, I came to ask permission rather than forgiveness.
Well, I'm just
And,
explaining it, 'cause
It's very difficult for me, I'm sorry.
Did you have that conversation with the zoning officer about your
Yes.
neighbors as presented?
Yes, and I have my neighbors with me. I'm-
okay, all right.
Matthew, I have one question, and maybe it's Rich as well here. I don't see where they're coming asking for a variance.
They're not.
They're not, that's what we discussed earlier.
I
You're
mean,
appealing a denial of a permit. Now, one way you can get a permit that you've been denied is to be granted a variance to allow you to do it. But the variance can only, by this board, can only be granted for a variance from the terms of the zoning ordinance. That's not the violation that resulted in the permit being rejected here. I assume we're gonna hear. It was rejected for reasons unrelated to the zoning ordinance's setback requirements, I assume.
What, may I?
I don't want to
add?
speak for the township, but I'm assuming that's going to be the argument. They're going to explain to us why this is a violation of the subdivision and land development ordinance.
May I add that I came before you and you wouldn't let me talk, if you remember, a few months ago.
Right, because the case wasn't
Because
here.
you still
It
had not
has to
done-
be on the-
you
Because the
had
case wasn't filed.
Right, because they wouldn't allow me to file a building permit. So I then filed a
No,
building permit. So
I'm sorry, Kathy, but
I understand.
they're not in the business of telling people they can't file things.
That's exactly what
I
happened.
doubt that
That is
very much.
exactly what happened.
Rather,
When our builder
excuse
talked
me
with
one second.
Julie.
Excuse me,
This is
this
irrelevant.
is not what we're here to discuss.
Okay,
I hate to
all
cut
right,
you
I'm
off.
sorry.
Let's stay focused on what we're here for.
All right.
Otherwise, we're gonna get
Okay.
all out of
Okay,
whack.
you made the point that other people have porches that go out as far as you want to go. You made that point. If there's other evidence we need to have that's supportive of it, let's have it.
All right, what I should probably let you know, that my husband and I did have a meeting with Attorney Shaw, and we sat down, and they proposed to us that we needed to contact 56 people in our subdivision, that we had to go to their homes, and that they would have to come to the township and have their signatures notarized, and then we could lift the building line for all 56 properties. That, to me, there is no way I would have gotten 56 people to come here and have their signatures notarized to lift the building line. They told me that it was beyond this, and nobody sent me to the county. Nobody sent me there. But I went to the county offices, and I asked many, many questions about subdivisions and why is this happening? And they said, we don't care what you do. We don't care if you do that. It doesn't matter. You just need a building permit. So I guess I'm very confused as to where my position is. Is it only God could change the building line? Who could change this building line so that I can have a porch?
you live in a subdivision, you bought a
Yes.
home that's in a
Yes,
subdivision.
we did.
Okay, that has a building line.
Yes.
Us as a board are not capable of changing that building line.
Who is?
Your subdivision could change, that's what,
There's no HOA.
that's what, I think an attorney advised you, was that that would have to be changed by all members of that
Yeah,
subdivision.
there is a
It's
way
nothing
to-
that is within our jurisdiction as a zoning hearing board to
Right,
change that.
Right. There's a way to modify a recorded subdivision plan. It's probably pretty, I'm not intimately familiar with it. It's probably pretty cumbersome. It might be very similar to what you just described. I don't really know. But this board can't do it. We have no jurisdiction whatsoever. We take the things that are recorded as they're recorded.
Mr. Perhacs, I'd like to get back and focus on only what we're here for.
Right,
We're not
please.
here to give legal advice, we're not here to give legal
Please.
assistance.
Totally agree.
That's what you're here to present to us, and the township is to be able to present or defend or attack. But again, we're here for something very specific, otherwise we could be here a week, and
I
at my
understand.
age, I don't wanna do that.
I understand, me either. I've been doing this for 8 months.
Okay, so the township, you rested your case, I guess?
At this point,
Or do you-
yes.
Well, do you have any other witnesses to present?
No, I've got lots of neighbors here.
That's not what I didn't ask you if your neighbors were here. I asked you if you had witnesses
No,
to
I
present.
have no
Okay,
witnesses.
all right, so there,
This is it.
so that's the end of your
This is it.
presentation.
Yes.
The only other comment I'll make is that if it's not called building line on the neighborhood plat, what else would it be called? There is no other term.
I wanna go back to the statement I made even to Mr. Perhacs. We're not here to give legal advice, that's why at the very outset of this, after the township, wanted to put on record their statement, that we gave the opportunity for you to be represented by counsel. We're not here to give legal advice, and, you know, we're only here to listen to what your request is, and that's truly all that we're here for.
Okay.
Okay?
So you have no ability then to help us?
That's not true. We have an issue that we have to decide. We're gonna decide a case. That's what we're gonna do. That's what we're supposed to do.
Think of
We're
us
not
as-
here to help anybody.
think of
We're
us
here to
as
make
the juror.
decisions, okay?
We're a juror, we're gonna listen to your case, and then we're gonna deliberate and decide, hopefully, what happened. But again, as Rich just said, we don't give advice, we listen and then deliberate.
Okay, so now it's the township's turn.
Thank you, Mr. Perhacs. Ms. Umpleby, I do have some additional questions for you.
Oh, that's true. She gets to ask you questions too. I'm sorry.
Not a problem. Ms. Umpleby, you indicated earlier that you attended a meeting with the township with Mr. Shaw.
Yes.
Was Mr. Waldinger also present, as well as myself?
I think he was. No, he wasn't. He was not there. Just the two of you were there, my husband and I.
And at that meeting, were you provided with an outline from the township of what you would need to do if you were to try and modify? And your understanding, based on the documents you provided in your supplemental materials, your letter of May, I believe 12th or 11th, was that because of the recorded building line, it violated, you were unable to obtain a permit because the building line would be violated by your porch.
Yes.
And so you're aware, though, that the issue is because it would be in violation of a recorded subdivision plan?
Yes, I am aware of that.
And to confirm as well, you're seeking an appeal of Mr. Puzz's determination
I am.
denying the
I am.
permit? And you're familiar with your subdivision map, though, that has a recorded subdivision line, or excuse me,
More
recorded
familiar
building
than I
line?
ever could want to be.
And so you're aware that it is a 30-foot building line?
I am very aware.
And have you contacted any of your neighbors regarding modifying the building line?
No?
In your that's correct. And you also testified that at the meeting with the township earlier in the year, do you recall the date of when that was?
I have it. I have the date listed on
Can
the.
you speak speak up so we can hear
Yes,
your
I'm sorry.
responses,
I
please?
have the date listed in my packet of materials. I could give you the exact date. I know that I have provided those letters to the entire board, and it's in that document also, and I could find it if you'd like.
And so the township made you aware at that meeting that because of the recorded building line, it could not grant the permit,
Yes,
and provided you with a mechanism to modify or remove the building line.
a very unrealistic, yes.
And as it stands, you've not taken any steps to remove the building line.
I have not.
And so with the subdivision, building line is still in existence.
It is?
And the township provided you with a draft agreement to modify the subdivision line, correct?
Yes, you did.
And you've not
I've done
contacted
nothing
anybody?
with it. I've done nothing with it.
That's all I have at this time.
Am I permitted to call Mr. Puz as a witness?
I asked you if you had any further witnesses, and your client said no.
So we-
Mr. Puz is going to testify. You cross-examine him,
Okay,
as long as you stick to the topic
sure.
that he's questioned about. Okay. All right, it's your case, Lydia.
Thank you. Mr. Puz, I'll call you as my first witness. Could you please state your full name for the record
Matthew Puz Jr.,
and your current occupation?
Zoning and Development Officer for Mill Creek Township.
And how long have you acted as the zoning and development officer for Mill Creek Township?
A little over 3.5 years.
And in your capacity as the zoning and development officer, are you responsible for reviewing applications for building permits?
Yes,
And in your capacity, did you review the Umplebee's May 21st, 2021 application for permit?
yes,
And did you issue a notice denying that application?
yes.
What I have here are copies of the application that was submitted. Would the board like additional copies on hand?
If it's in our package, we don't
It
need
is in
it.
your packet.
No, we don't need it.
Mr. Puz?
Thank you.
Do you have a copy of the packet that was provided?
I'll take a copy. Thank you.
No, Mr. Puz, the document I just handed you, is this a copy of the application for permit and notice of denial for the Umplebee's property?
Yes,
And your notes and signatures at the bottom, are those yours in the blue pen?
yes,
And on the second page, is that your signature?
yes.
And what were your reasons for denying this application?
The application was denied because the proposed porch would exceed or encroach past a recorded building line.
And that would be a violation of section 145-108A2 of the subdivision, the zoning ordinance?
Yes,
And that section of the zoning ordinance concerns when you can issue a permit, correct?
that is correct.
And if I may direct you to section 145-108A2. I have a copy too, if that's easier for you, Matt.
So, is it 145? Shoot, I have that. Okay.
Could you please read A2?
145A2. Let's see, 145-108A2 permits action on application. If the application does not conform to the requirements of all pertinent laws, the zoning administrator shall reject such application in writing, stating the reasons therefore.
And was that the reason that you rejected the application, is because it didn't comply with the applicable township ordinances?
Yes,
And did the property owner file an appeal to your determination?
yes,
And they're not seeking a variance, correct?
that is correct.
And what is the zoning district for this property?
That is R1 single family residential.
indicated in your testimony that the application did not conform, and the nonconformance was related to the SALDO, which is the subdivision and land development ordinance, correct?
Correct.
And how did the application not conform to the SALDO?
Per the CELDO, the building line as defined does not permit structures beyond it.
Can you refer me to a specific section?
Certainly.
You're gonna do that?
Yes, that would be 125-6.
Okay, because I don't think
And I have a
I
copy
have, I
of
don't have
that.
that here.
I don't have, you do not have that in your packet. So- Mr. Puz, could you please refer to the section 125-6 and read the definition of building line?
Yes, building line, a line within a property generally parallel to the street line between which and the adjacent right-of-way no structure may be built.
Yeah, this is the key right here.
And how long has this subdivision and land development ordinance been in effect?
The current one,
Yes, the current one.
2006. July 11th, 2006.
And is it required that subdivisions include a building line?
Yes,
I'm gonna direct-
Is that elsewhere in the ordinance somewhere? Does it say that
Yes, it
specifically?
is.
If you could identify that for me, please? Or maybe you're going to. I assume you were. I'm sorry.
No, you're,
Might be
You're fine,
go
it's
quicker if I
perhaps.
just shut up. but-
if you have the section at hand.
yes, that's, would be section 12543, final plan application requirements for major subdivisions, C. Let me find it.
Requires a building line. That's what you're telling me. That's it.
Yes, C34, the final plan application shall show building lines.
Okay. So the subdivision ordinance requires that the recorded subdivision plan have a building line.
Correct,
And the subdivision and land development ordinance further defines building line as the space into which you cannot build. Right? That's
Correct.
the definition.
That's in this document you just gave us?
The definition is.
I do not, gentlemen, I apologize, I do not have a copy of that particular section of the subdivision and land development ordinance, the 125 dash.
43.
yes, 43,
43.
C34.
I have copies, if you'd like it.
Yeah,
It's
if you got an extra one, sure.
Yeah, 125.
I mean, it's not, it doesn't have to be evidence, it's not evidence, it's the law. I mean, we can
It's-
look it up, and if we'd all
Thank
take
you.
10-minute recess and go grab a copy of it.
This is not all of the 125.
Well, that's okay, I only need the relevant part. It's 12543, what was the subsection, Matt?
C34.
C is in,
C is in cat,
C is in cat.
34 is in 34.
Oh, C33 and 4, okay.
And Mr. Puz, I'm going to direct you to section 145 dash 105 of the zoning ordinance. I have a copy on hand if you prefer.
That's the case.
This is marked previously as Exhibit 2.
This is ridiculous. This is so clear.
Okay.
Specifically to section F, which is conditions of permit, subsection 7.
Just let her finish. I mean,
Okay.
In order to issue permits, would the application and the project need to comply with recorded building plans, any structures, buildings, renovations, or other additions located within a subdivision or land development previously approved by the Board of Supervisors? Would the owners need to comply with those requirements in those subdivisions?
Yes,
And is that what section 145-105 FC7, 145-105 F7 requires?
yes,
Did the application as submitted by the Umplebees comply with the recorded subdivision plan?
no, it did not.
And how did it not comply with the recorded subdivision plan?
the proposed porch, the proposed open porch was to extend beyond the building line.
And Mr. Puz, are you familiar with the map for the subdivision in this subdivision, in the Westminster Colony subdivision?
Yes.
I've previously marked this as Exhibit 1.
Can I go back, just, how do we want to clarify this exhibit that was presented by Mr. Umpleby? Because it was presented,
It's the ordinance, and I know that it's part of, I mean, I'm happy to mark it as an exhibit if you would prefer it that way, but I
Yeah,
know that
it's
the
really not
ordinance
evidence.
is, it's not really evidence,
It's the law, you know, it's just for
I'm
your
just-
information.
you generally, I'm trying to provide you copies if you don't have them, and I apologize, I didn't have this copy on hand.
I just want to make sure you didn't want to have this identified in any fashion.
No, it doesn't need to be really.
Okay.
Mr. Puz, is this a copy of the recorded subdivision for the Westminster Colony Plaza 2?
Yes.
And is this a subdivision where the Umplebys currently reside?
Yes.
And on this map, is there a building line indicated?
Yes.
What is the building line?
30 foot.
And when you see a building line indicated on a subdivision map, what does that mean?
No structure is permitted to be built beyond it.
And this map does not say that this is a setback line.
Correct.
And in terms of open porches, let me back up. Does the subdivision, excuse me, does the zoning ordinance define building line?
No.
And in evaluating this application, did you consult with the subdivision map before issuing your denial?
Yes.
Mr. Puz, have you previously, to your knowledge, issued any permits for projects that would extend beyond a building line?
No.
Is it the township's practice to deny permits where the proposed project would extend beyond a recorded building line?
Yes.
And in the 3.5 years, I believe you said you've been with the township, do you recall issuing any building permits for properties where the project extends beyond the building line?
No.
That's all I have for you this time, Mr. Puz.
Now, if you wanted to cross-examine Mr. Puz, this is your opportunity.
Thank you. Mr. Puz, you've already noted 125-43 as a basis for your denial. I was wondering if you could please read out loud subsections 33 and 34. They're on the second page of the handout I gave you.
Yes. Let's see here. So, final plan application requirements for major subdivisions, 125-43C. The final plan application shall show 33 setback lines not less than the minimum established in Chapter 145 zoning and as otherwise established in this chapter or by other applicable laws, regulation, or deed restriction, whichever is greater, and 34 building line.
Thank you. Don't these sections require that front yard building setback lines established in the zoning ordinance be noted on lots in the proposed final subdivision plan?
Yes, setback lines not less than the minimum established.
Okay. So a front building setback line is shown in a subdivision plan to make sure that parcel complies with the zoning ordinance, is that correct?
Correct.
What is the minimum front yard setback I'm sorry, you already answered it. For R1, the front yard setback is 30 feet, so I apologize for repeating. Is that the regulation set forth in Code Section 145-18, subsection G, number 1?
Yes.
Okay. And what is the minimum side yard setback for properties in the R1 district under that section?
Why is this relevant, Mr. Umpleby?
Because section 145-19, when it talks about open porch, it does address not going into the side yard setback lines.
Yeah,
So
but
I'm
your
just
per- but your-
establishing that that is not a basis for denial.
But your permit wasn't rejected on that basis, he's already said that.
Okay?
I mean, we need to move along. I mean, I understand that you're not a professional doing this, but we need to stick to what's relevant to the issue.
Okay. Does the zoning ordinance generally prohibit construction of a structure within a setback, whether it be for the front yard, a side yard, or the rear yard?
Yes.
Does not the zoning ordinance at section 145-11 call that line beyond which a structure cannot be built a building setback line?
That section does state building setback line, which is a defined term.
Okay? Did my parents submit documents besides just the one-page application?
Yes, they submitted several documents
Okay.
with their application.
Did the plan that they submitted propose that there would be a porch with a roof but no walls?
I do not see any building plans in the application.
You didn't get the plans from the builder?
Unless I'm missing something.
If you're gonna speak, you're gonna have to be,
Yeah, one
you're
at a
gonna
time.
take some time to be recognized
We
as
don't
well.
take audience comments.
Is that their submission? So the application that was submitted to Julie Maggio does show an open porch, well, a porch with no walls,
Okay,
other than the house.
okay. In the house as it currently sits, it's in compliance with the front, side, and rear yard setbacks of R1, is that correct?
Correct.
Okay. The application with the accompanying documents, it did say that the porch would not extend more than 10 feet beyond the building line, correct? Or 10 feet from the front of the house.
The initial application, I do not believe was drawn to scale,
Okay,
but it does show 10 foot.
so if their house is currently behind the building line and they're going no more than 10 feet, they would be less than 10 feet out from the front of the house, or they would be less than 10 feet across the building line, correct?
Yes.
Okay. Did the application propose that the porch would extend beyond the side yard setback line?
No.
Are you familiar with section 145-19 of the Township Zoning Code?
Yes.
Okay, I think you have it. If you don't, I can give it to you.
I do have it, thank you.
Okay. This section is entitled Accessory Buildings and Structures, correct?
Yes.
Okay. Would you please read out loud subsection F?
Wait a
of
minute,
this?
wait a minute. He doesn't have to read the ordinance to us, okay? We can look it up ourselves.
Okay.
We can read it ourselves. This is burdening the proceeding unnecessarily. What is the point of this?
My point is that what the definition of open porch and what this ordinance allows them to do are one and the same.
Okay, you're confusing evidence with argument,
Okay?
okay? You'll be permitted to give a summary of your legal position, your argument on what the ordinances mean as a question of law. You don't need to ask Mr. Puz to read them and to recite them, or to give his opinion on it, because frankly,
Okay.
he's not capable of doing, he's not competent to do that. So,
Okay,
so just stick to facts, things
Okay.
we know, for instance, that what you want to do is go 6 feet farther. We know that already. It's been
Okay.
covered about 6 times, okay?
okay,
So let's just stick to things that we don't already know.
okay. Did your decision here cite any failure to comply with section 145-19, letter F?
No.
I don't have any questions.
Okay,
I do have some redirect for
Sure.
Mr. Puz.
sure.
Mr. Puz, you were directed to sections 33 and 34, excuse me, section 145-43 of the subdivision ordinance, subpart C, section 33 and 34.
Yes.
And are building lines and setback lines different concepts?
They are two separate defined terms. Yes.
And does the subdivision ordinance include a definition of building line?
Yes.
And you previously indicated that it would be that no structure may be built beyond a building line, correct?
Correct.
Does the subdivision ordinance include a definition of setback line?
Yes.
The subdivision ordinance?
Yes. Setback line, a line parallel to a lot line at a distance from the lot line in accordance with the yard perimeter or setback requirements of chapter 145 zoning.
Thank you, Mr. Pez. And under section 33, section 125-43C33, it references that the setback lines must not be less than the minimum established under the zoning ordinance. Is that correct?
Correct.
And does the zoning ordinance include a definition of a setback line?
Yes.
And does the zoning ordinance include a definition of building line?
No.
You were also directed by Mr. Umpleby to section 145-19, specifically subsection F, concerning open porches.
Yes.
And his position is that the setback and the building line are the same thing. Is that your understanding?
That is my understanding of his position.
Now, based on the language that is specifically included in section 145-19, it references a building setback line. Is that a defined term within the Mill Creek Township zoning ordinance?
Yes.
And is the building setback line the same line as a building line?
No.
And why not?
They are two separately defined terms. One's defined in the zoning ordinance and the other one, the building line's defined in the SALDO.
And in making your determination concerning the application for permit, the denial was based on the fact that it violated a recorded subdivision line, correct?
Correct.
I don't have anything further for you, Mr. Puz.
Do you have any other witnesses?
I do have one additional witness that I will be very brief for you, gentlemen.
Good, go right ahead.
I'm calling Mr. Matthew Waldinger.
Why don't you go to the podium, and Mr. Umpleby, why don't you relinquish that for him? Thank you.
Mr. Waldinger, could you please state your full name for the record
Matthew Waldinger.
and your occupation, please?
I'm the Director of Planning and Development for Mill Creek Township.
And how long have you acted as the Director of Planning and Development for Mill Creek?
Approximately 4 years.
And prior to that, what was your position?
I was the Land Development Coordinator.
And are you familiar with the request of the Umplebys to construct a front porch on their property that would violate a recorded building line?
Yes.
And have you reviewed the permit application and appeal filed by the Umplebys?
Yes.
And what is the township's position with respect to issuing permits for projects that would violate a recorded building line?
We would not issue a permit for anything that violated a recording building line.
And it's so that it is the township's current practice then to deny those permit requests?
Yes.
And prior to the zoning hearing board, Mrs. Umpleby indicated that she had a meeting with Attorney Shaw and myself. Were you also present at that meeting?
I was present. I was wearing a mask at that time, so maybe, but yeah, I was at that meeting.
And at that meeting, did the position of the township, was that communicated to Mrs. Umpleby concerning the building line? That was communicated to her?
Yes.
And what is the township's position with regards to how she can modify the building line?
She can modify the building line by having a petition signed by each of the owners of the lots within her subdivision. That's the answer, sorry.
And if there was a homeowners association or a developer, could they modify that line?
Yes.
And with respect to the Umpleby subdivision specifically, you're familiar with that
Yes.
subdivision? And you're familiar that it has a 30-foot building line?
Yes.
And it's all, not gonna further, because that would be repetitive, and I don't want to drag the board's time on any longer. I believe that's all the questions I have for you, Mr. Waldinger, at this time.
Thank you.
Mr. Umpleby, you, I think now can question Mr. Waldinger.
Yeah, if you have any questions of
Any
Mr. Waldinger, I don't know if you do or not.
He's a witness.
Okay, thank God, then you can sit down. Is that your last witness, Libby?
That is my last witness, yes.
No, maybe not.
One second, please.
Sure. It's a weird case. This is so simple. This is a freaking no-brainer. I mean, if you buy their position, you can just totally disregard the subdivision. We could.
We'll come back.
No, that's fine, take your time. I believe I'm in exhibit number 4, if I'm recalling correctly.
You would be at number 4. is what I
Okay,
have.
that's what I thought.
Okay.
Gentlemen, I'm going to provide to you a copy of an email chain, two separate email documents, but as part of the chain, with my correspondence with the Recorder of Deeds, Dave Bradford, concerning modifying a recorded subdivision plan,
Okay.
and how, in the agreement that we provided to him, and he reviewed it and concurred that that was how you would modify the recorded building line.
Was it shared with the Umplebys then?
The recorded building line?
No, this email.
This email, no, I'm gonna provide them a copy as well.
Okay.
But was the information that was contained in the email shared
They
with
have a
them?
copy of the agreement that was provided to them.
Okay. What they would have to do to change it?
But
What they would have to do to
it.
change the
Correct.
building line,
Correct,
once it's recorded?
correct.
Okay. That's what I thought it was.
And for the record, Dave Bradford is the current recorder.
Fully aware, thank you.
Mhm.
I appear to have an extra one. 5. I have a 4 and a 5.
Did you have another 4 for Mr. Perez?
Oh, I'm
No, I have
sorry.
a 4.
Do you have a 4?
I have a 4 and a 5. I have two 5s.
Oh,
We have 5 squares.
I feel like I'm making change at Country Fair or
you need a
something.
4.
Here, I don't need,
We don't need.
I don't need
five. Unless it's a $5 bill.
I don't think I have any of those, I don't carry much cash these days.
I have a
He
4.
has it.
I had 2 5s.
He had 3 documents. He had a 4 and 2 5s.
And if you have a $4 bill, I want to know where you got it from.
I run operation out of the basement, you know.
The Secret Service will hunt you down for that. The NSA, she really didn't say that.
That's true, we're all being watched.
That's all I have.
There's
at this
nothing in
time.
my emails they want to see, I can tell you. Okay, any further?
Nothing further.
Any further evidence? Any further comment of any sort? We're going to close the record very quickly here.
Mr. Umpleby, you don't have any comment on this document?
It looks like Mr. Umpleby, either of you have anything else to say?
Okay, we'll take comments from other people, including this gentleman.
Good evening. My name is Robert Umpleby. I reside at 2916 Broadlawn Drive. The only point I wanted to bring up, and it's covered somewhat, but there is an ambiguity involved here about building line and building setback line. And especially if you go back 60 years ago when the subdivision was established, back at that time, everything seemed to have been called a building line. They didn't use the term setback line. And for example, I've looked at every page of just about every book in the Mill Creek property map book, and everything in that map book, as far as the front setback line or front building line, everything is described as building line. And it seems that not every one of those properties on all those maps, that it would be a building line. And also, if I could have a second here. I also looked at the attachment to 145 where it talks about building setbacks, and even in the diagram where they're showing the sides, rear and front setbacks, they use the term building line even in that diagram. So what I'm saying is, even though the colony map shows building line, I think there's a certain ambiguity involved here, that it seems to me that building line was used whether you were talking building setback line or building line. And I think as Mike had said earlier, building line was strictly for the development of the subdivision. I have a feeling that if Cloverleaf Homes Incorporated still existed, and they could have a representative here, and we could ask them what the intent of building line was on their map. Was it a case of not wanting forever anything to go beyond the building line, or was it a case of they had to put building line on the map in order to get their plan approved?
I understand what you're saying there. Unfortunately, they're not in existence, so we can't ask for that definition.
Yeah,
But we take your testimony for the record.
Thank you.
If I may ask some questions of Mr. Umpleby?
Sure.
Please.
Mr. Umpleby, you indicated that you looked at the township maps and there was indications of a building line. Is that correct?
Correct.
Did you look at any of the actual subdivision maps to determine if there was a building line?
I was not able to determine where I could get a look at subdivision maps. But my thought is if all of these division maps in every map book says building line, I can't believe that all those properties in all those books would be forbidden to ever have a structure beyond that line. I found in looking at the Embrace Mill Creek.
Mr. Umpleby, that sort of goes out beyond the question of whether or not you looked at the maps, the actual subdivision maps. You've not.
I have not looked at any subdivision maps. I was not able to
So you
figure
don't,
out where I could get them to look at them, or I would have.
so you don't know for certain if these properties
Get your
on these
chairman
maps
in
have
there.
30-foot building lines?
Excuse me, I
What-
understand where you're going, trying to build a case, but really, we're not here to determine whether he looked at a subdivision map or,
I don't care what he looked
any
at.
other, he gave us some testimony
Oh.
that he looked at some maps.
What I was gonna say, and if I may continue, was that I had looked at the Embrace Mill Creek website, and I learned that 85% of Mill Creek is made up of subdivisions. All subdivisions, for their development, had to include a building line. That makes me wonder, is 85% of the Mill Creek residences not gonna be able to take advantage of this ordinance 145
That's irrelevant, sir.
Excuse me, sir. If I-
19
if I-
Doesn't matter.
If I
that
could
the,
just-
that the supervisors
It doesn't
added?
Excuse me,
matter,
sir.
It doesn't matter.
I think it does matter.
Excuse me, sir.
Why would the supervisors
There-
put
there's-
an
Mr. Umpleby,
ordinance?
Mr. Umpleby, there's been a request by the chair. Please listen to the chair. Thank you.
If I could make one statement, we're confusing, we've taken all this testimony, it's very, they've made their point, there's a building line on the subdivision plan that can't be built beyond, okay? Don't confuse building line and the setback, they don't have to be the same, just because they are the same in that instance, they don't have to be the same. We have to follow the laws that are here, we can't go back in time and talk about what a developer's thoughts were or anything else, okay? And we can't just sit here and belabor the same points over and over again. If there's any new information, that's what we're here to accept at this point, or else we can be here till midnight. So if we're talking the same thing over and over,
Ultimately, there's been a lot of evidence presented, but we're only here to talk about the request of the subdivision. Has nothing to do with zoning or anything else. So, to the chair's point, if there's other people in the audience that'd like to make some comments,
feel free,
come
please.
forth and be recognized. Remember, if you show us anything, including your phone, we have to keep it for 60 days. If you show it to us on that, in all
Yeah,
seriousness.
we've
if
had
you
this,
show it to-
we've had this issue.
I didn't say I was gonna show it. Just give me 1 second. I'm sorry. I was looking up something while everyone was speaking, and I just wanna find it here.
We need your name and address, please.
Yes. Okay, hello, hi. My name is Brigida Francoeur. I am a longtime neighbor of the Umplebys, 40 years as a matter of fact, and I live directly across the street from them. And I babysat these kids, who are now adults. I do not mean to hold up your time. I know everyone wants to get out of here in a timely fashion. Basic bottom line, they are dear neighbors. They're not asking to build the Taj Mahal. They are adding a small, may I continue?
Mhm.
I'm listening.
They are
Well,
adding,
excuse- the
There's a lot
gentleman
of
who's
noise
talking,
behind you over here.
please.
Thank you.
anyway, they're dear neighbors of mine for 40 years. They're not asking to build the Taj Mahal. They're asking to build a small porch on the front of their home, which Umplebys have very wonderful taste, I can tell you, because I look at their house every day. This was meant to be, is my understanding, a friendly meeting just to discuss this, and I found it very adversarial. And I was kind of disappointed in hearing that, because they are very wonderful people.
Do you have something to speak to about the case as opposed to?
Building lines are a
Thank you.
specified distance from the sides of a lot that denote where the building or structure cannot be placed. Building lines are often called setbacks because a building must be set back a specific distance, a specified distance from the property line. I know you had gone in circles around with this. Very easy to look up. Basic bottom line, they're just asking to put a small porch on their home. And I think it would be a nice idea. We have other neighbors here representing them as well. And I would hope you would consider that. That's all I have to say. Thank you.
Am I permitted to ask a question?
Yeah, but please be very direct.
Okay.
With regards to what you read, where did you read that from?
You can find it anywhere on the internet.
It's not part of the Mill Creek Township ordinances.
No, it is not, well, I don't know that for a fact. I don't
That's
know
all.
what it is. Okay. Okay?
Thank you.
Thank you.
Thank you.
Is there anyone else with any new information?
I wonder who does that.
Sir, you were standing up previously? Excuse me, you'd have
If you
to
wish to
approach
speak,
and
you indicated you
state your
do,
name.
so this is your opportunity.
Excuse me, I need you to state your name and address.
Oh, of course. My name is Rob Umpleby, and my address is 4510 McCreary Road in Mill Creek.
Thank you.
And Bob and Kathy Umpleby are my parents, so I don't pretend to be unbiased in this situation. However, I don't have a legal statement to make here, so perhaps I shouldn't be standing here right now. So I'll be brief. I grew up at 2916 Broadlawn Drive. I've watched my parents be model citizens, paying taxes to Mill Creek for 40 years. That is not a new neighborhood, obviously. It's rather old. It depends on people like my parents and other people on that street who have done a wonderful job of trying to improve their properties. I guess I would hope that, well, it seems like a win for them, for the township, to continue to improve their property. They're asking just to put a porch on the front of their house, which really sends the message that it's a safe neighborhood, and where people like to be outside. And I'm just, I guess, wanted to say that I hope that the township and everyone here would at least consider the common sense of that. A neighborhood like my old neighborhood depends on people like that to continue the improvement. And thank you very much for taking that into consideration.
Thank you, but
Thank you.
let us be clear from the board's perspective, or particularly mine. We've never taken in question your parents' character or commitment to the community or anything else like that. We're only here to discuss an ordinance that the township has and your parents' request to overturn a decision by the zoning board. So we never questioned anybody's character.
Understood. Thank you for that.
Thank you. Anybody else with any comments?
Is it new?
Yes, I'll be brief.
Better be new.
As part of this process, ads were put in the paper and a sign was put in their yard notifying people that this appeal was happening. My thought is if it's as cut and dry as you seem to think it is, why were those steps taken?
We're required to publicly notify people of a request for a variance or a objection to a ordinance such as this. That's a public requirement.
And can anybody answer, did anybody voice any concern or any opposition to what my parents want to do?
That's not our concern. The only requirement of the township is to notify people. Whatever happens beyond that isn't, again, going to be a part of what decision this board might make.
That's what these hearings allow people to testify for or against.
Okay.
Is there a reason, now, I'd like to ask this question back. It sounds like the concept of applying for a change of this ordinance was presented. Is there a reason that was never pursued?
Because it'd be virtually impossible. We know of at least a couple people that are homebound, of probably questionable mental capacity.
Well, excuse me a second, it sounded like the information that was presented via these emails didn't require people to come to the township. It sounded like it was a request for your parents to circulate a petition.
Oh.
There was,
It would be an agreement, based upon my discussions with the recorder of deeds. In recording a deed, it needs to be a notarized signature. So Umplebees would have needed to have obtained the signatures for all of the recorded property owners in the subdivision, and those would be notarized,
with the notary attesting to it.
attesting to
Right.
their
Okay.
signatures that are their signatures.
So it wasn't incumbent upon the Umplebees to bring people here. If they would have hired a notary to go with them to get things signed, that would have met the requirement. So it wasn't,
Yeah, it's a bit cumbersome, but the reason is because the people who own properties in that subdivision are entitled to rely on the restrictions in the subdivision, including the building line. And if somebody in there didn't want something sticking out into the building line, they have a right to be opposed to it.
correct, but it wasn't gonna be incumbent upon the Umplebees to convince people to come to the township.
No,
If they would have gone with the notary to everybody's door, that would have
Correct.
been
My understanding is it requires notarized signatures.
Yes, and the township
however they're.
by direction of the supervisors, made our notary at the township available to the Umplebees and their neighbors should they come to the township to do that.
Okay.
I mean, it's a bit of a job to do. I mean, it's not easy, and it does require procedure, but it is possible.
So that is an avenue that could be pursued.
Oh, yeah.
Okay.
Could be.
I just want to have this
Yeah.
cleared in my mind because I've listened to an awful lot of stuff tonight.
Yeah, but that's not, they don't have to.
Is there anyone else like to comment?
All right, let's get out of here.
Okay. We're going to adjourn and discuss these cases, and we'll be back. And if you'd like to stay and wait to hear the outcome, you're welcome to. If not, you can contact the zoning office after 8 o'clock in the morning. Okay, let the record show, we came back in session at 9:29, and we're gonna give you our feedback on these appeals. So, appeal number 21-14, do I have a motion?
I will make a motion that we approve based on the stipulation of 12 parking spaces and no sidewalk relief.
Do I have a second?
I'll second that.
All in favor?
Aye.
All opposed?
And let the record reflect that the chair in this case did not take testimony and did not read it, so it's only Mr. Calhoun and myself who could vote on this tonight, so it's a 2-0 decision.
Appeal number 21-15, Richard and Aaron Polinsky. Do I have a motion? Do
I'll make a motion to approve.
I have a second?
I will second it.
All in favor?
Aye.
Aye. All opposed? So moved. Appeal number 21-16, Meadow Green Acres. Do I have a motion?
I'll make a motion to approve 21-16.
Do I have a second?
I'll second it.
All in favor?
Aye.
Aye. All opposed? All in favor? So moved. Appeal number 21-17, Randy Woyicki.
I make a motion that we approve 2117.
I'll second that motion.
All in favor?
Aye.
Aye. Appeal number 21-19, Robert and Kathy Rin Umpleby. Do I have a motion?
I'll make a motion to deny 21-19.
I will second. Do I have how many are in denial?
I vote to deny.
I do.
Which,
On 21-19.
were you seconding it?
I made a motion, yeah, I made the motion, he seconded it. We're now, the vote is, we're voting to deny. Your vote is what?
I agree.
Okay, 3-0.
Okay. 3-0.
Okay.
Okay.
I'll make a motion to adjourn, and just for the record, because this is a quasi-judicial decision-making group, we can't have any discussion with anybody in the room about any decisions we made one way or the other tonight, because all these cases are open to appeal. Thank you very much.
Okay. Thank you.